Hello, my name is David Zipp. I'm an Illinois licensed attorney and one of the founders of ZippToCourt.com. Today's presentation is on the Illinois Equine Activity Liability Act. There are many hyperlinks in this presentation, and I urge you to go to ZippToCourt.com and go to the Zip to Equines banner, and where you can find a PDF, a downloadable PDF for free that will have all the links readily available for you. And again, this presentation is on the Illinois Equine Activity Liability Act, which is the 745 Illinois Compiled Statutes 47/1, last updated in the year 2000. You can read the general law of the ILGA, the link below. As an aside, I want to stress to people that www.ilga, which is IllinoisGeneralAssembly.gov, is an excellent resource for finding the actual law in the state of Illinois. The Illinois Activity Liability Act is basically a very fancy statute that seeks to protect equine professionals from liability by reducing the risk of lawsuits for injuries arising out of the, quote, inherent dangers, end quote, associated with activities involving horses. Basically, if you own, use, sell, have anything to do with horses in the state of Illinois, this Equine Activity Liability Act is of pertinence to you. What is the purpose of this act? It's to promote and encourage equine activities and economic benefits derived from such activities. Throughout this presentation, equine obviously does mean horse and horse-related activities. To encourage equine activities by limiting the civil liability of those involved in such activities. What are some of the equine activities covered by the Act? They include horse shows, horse fairs, competitions, performances, parades involving horses, rodeos with horses, horse polo, performance riding, trail riding, riding instruction and related training, the boarding of horses, shoeing of horses, and pretty much anything else you can think of that involves equines in Illinois. What does this act do? This is very important. The assumption of the risk defense. This actually is an affirmative defense that allows horse owners and stable owners and fair managers to have an affirmative defense, which means in court, what this allows you to do is offer something up right away, which is, quote, each participant who engages in an equine activity expressly assumes the risk of and legal responsibility for the injury, loss, or damage to the participant or the participant's property that results from participating in equine activity. Now, I know that's a big sentence, but what that effectively means is that if you decide and you knowingly choose to be involved in the equine activity, the person who gave you the horse is not automatically liable. And that's a huge deal. That's a very big deal in Illinois tort law. There are notice and signage requirements, and there must be a posting of a sign with a statutory mandated warning notice. That warning notice must be in every written contract entered into a professional, and a failure to comply with this may disqualify any immunity. This is the actual notice right here. I say Illinois statute mandated warning notice, and I have IE post this. And this must be posted verbatim, even of course with a source at the very bottom part. It says, warning, under the Equine Activity Liability Act, each participant who engages in an equine activity expressly assumes the risks of engaging in and legal responsibility for injury, loss, or damage to person or property resulting from the risk of equine activities. This is critical. This must be posted in your stalls. If you have a changing area, I would do it there. If you have common areas, I would do this multiple times. You can take this page, I would take the IE, post this off, print this off yourself, and put it behind a frame and put it on your barn, put it in your stable, and absolutely cut and paste this language in verbatim, including the source, the PA 89-111, effective 7/7/95, into every contract, every waiver of coverage, everything you do in the state of Illinois. Requirements. To be involved for the Illinois Equine Activity Liability Act to kick in, you've got to be involved in an equine activity. Control may be key. Voluntary participating in an equine activity. Defendant is a professional. There has to be notice and signage. There's no exception that applies, and there's no gross negligence. Wanted to cover this just briefly, what gross negligence is. Gross negligence is not ewy disgusting. It's a legal concept, which means a serious carelessness. Negligence is the opposite of diligence. You notice these are hyperlinked here. I've actually hyperlinked them to the wiki because actually wiki's a pretty good way to find definitions for things sometimes. The standard of ordinary negligence is what conduct one expects from the proverbial reasonable person. This is a reasonable person would be what would the average person or the average juror think, or a judge for that matter, think was done. By an analogy, if someone has been grossly negligent, they mean they have fallen so far below the ordinary standard of care that one can expect to warrant the label of being gross. There are exceptions to the Act. Faulty equipment is an exception to the Illinois Equine Activity Liability Act. Suitability of equine for the participant. This ranges from any number of areas, and it gets to very complex, but basically you don't put a new rider on an unbroken horse. So you think of it that way. Dangerous latent condition. This is stuff that you knew about or that you should have known about, and that was just there. Puddles that go through old rotted out barns, things like that. Willful and wanton conduct. You're not allowed to put somebody on a horse and then scare the horse so it throws the rider. The Illinois pattern jury instructions. Now, what Illinois pattern jury instructions means is that this is what typically is utilized in an Illinois court of law when a case involving equines is used. The pattern jury just means it's a pattern that's used over and over again so that we get fairness in the court systems. And this is what your juror will hear, more likely. Behavior which, if not intentional, shows an utter indifference to or conscious disregard for the safety of others. So that's going to be the standard that the other side that's suing you as the horse owner is going to have to show if they're trying to say that the Equine Activity Liability Act doesn't protect you. And obviously intentional misconduct. Anything that you do purposefully that would violate the implied concepts of this of the Equine Activity Liability Act. There are a few cases that are on point that I thought were necessary to mention. Well, in Illinois cases specifically. Carl versus Resnick is a 1999 Illinois appeals court case, and Judy was a lady riding a horse on the trail of the Cook County Forest Preserve when basically her horse was kicked by a defendant's horse, and it hit her, kicked her horse, and caused some injuries. The defense was the Equine Act by the other rider. And what the court said, they observed the plaintiff's complaint against the defendant was not barred by the Equine Act unless the defendant's recreational riding of her own horse on the public trail was one of those limited activities sought to be encouraged by the Act. Here's what the court found. They determined that there was no conflict between the Illinois Equine Activity Liability Act and the Animal Control Act. And the court reversed the trial court's order denying the plaintiff's motion for summary judgment and entered a summary judgment for plaintiff on the count one as a liability under the Animal Control Act. What this means is it's kind of complicated, but what it basically means is that the Animal Control Act, in effect, says that you're responsible for any animal under your control, and you're by way of a comparison, you're also responsible for any damage they might cause. Judy here was kicked by another person's horse, and she was and the other rider defended saying no, the Equine Activity Liability Act says that Judy consented to this. This is, in fact, what the court said is that is not the case, that simply two horses riding on a common trail, that you're both responsible for yourself and your horse. And that is important. Another case that I felt was on point is the Illinois Court of Appeals case from 1999 of Lesman versus Rhodes. And this is a particular mention, a note for those of us who are involved in horse shows or do hunt scenes or do any time where they bring people together who oftentimes are bringing other horses that you may not own yourself, but you're responsible for in the sense that you put them all together for your show. In this case, a guy was on a horse, he was on a stallion, and it bucked and it kicked him, and of course someone's going to pay when someone gets bucked and kicked is going to be the show's sponsor. The stallion rider and the owner there was all kinds of alleged negligence and willful and wanton misconduct, and alleged that you should have conducted background checks. I don't really know how you would do that, but somehow that's what the allegation was. And the defense, of course, was the Equine Activity Liability Act, which was established to shield those persons who participate in equine activities from liability. And it provides an exception to the general rule by permitting liability for equine activity sponsors that commit an act or omission that constitutes willful or wanton disregard for the safety of the participant and the act or omission caused by the injury. In this case, a plaintiff failed to provide evidence that showed the defendant's behaved in a reckless and intentional manner. Therefore, the summary judgment in favor of the defendant into the trial court was found to be proper. Now, what this means is that, again, we talked earlier about gross negligence. That is a standard that your opponent is going to have to overcome. So when you have a horse show, make sure, again, you've got the Illinois Act posted. But most importantly, understand that you can pretty much, as long as you did the right thing and you're doing a general level of care, you should be protected. And in Lesman versus Rhodes is an excellent case to keep in the back of your mind, maybe keeping your show's information. Just know that you are protected from liability from just conducting a proper horse show. Another case is an Illinois case is the Illinois Court of Appeals Court from 2005, Smith versus Lane. This is a horse-drawn carriage case, and this was a strict liability case against the driver of the carriage and the owner of the horse when the carriage went off the road and overturned. The lower court dismissed the passenger's counts. On the appeal, though, the appeal court held that, as a matter of first impression, the passenger was not subject to the Equine Activities Liabilities Act, and alleged facts sufficient to state cause the action under State Animal Control Act. What this means is that, and this is a distinction for those of you who do horse-drawn carriage rides around the holidays, or do any sort of hay rides around Halloween, that type of thing, that you're effectively what's called a common carrier at that point. Those people have consented and get to a ride, yes, but they are not actively involved in the equine activity. They're being pulled by the equine. And the court has, in Smith v. Lane, made a distinction between rider and passenger. A common carrier, and any lawyer can explain this to you, you can look it up very easily on the internet, means that a higher standard of care is held to people who are innkeepers, bus drivers, taxi drivers, and in this case, horse-drawn carriage drivers. So keep that in mind depending on what you do with your personal activities. Another case of merit is the Friedley v. Kerr case, a 2001 case out of Tennessee Appeals Court. And in this case, there were two people who were injured when the horse-drawn carriage that they were riding and turned over after the horse was startled and the driver lost control of the horse. The trial court held, and the Court of Appeals affirmed, that the defendant's carriage business was not immune from liability to its passengers under the Tennessee Equine Liability statute. There were three reasons for this decision. Number one, the defendant is not an equine activity sponsor. Number two, his business was not an equine activity. And three, the plaintiffs were not participants engaging in equine activity when they were injured. Now, this is important to realize that, yes, this is a Tennessee case, but look at the situation here. These were riders in a horse-drawn carriage, not active participants on a horse. And it's a distinction you might want to keep in mind when you make selections as to how you want to set up your liability, your risk management, and your liability issues. Obviously, a horse and rider is going to be subject to that Equine Activity Act, regardless of whatever state it is. But in this case, if you're pulling somebody on a hayride, if you're pulling somebody on a horse-drawn carriage, they're entitled to a higher standard of care. Now we come to Kangas v. Perry, which is a Wisconsin appeals case from the year 2000. The plaintiff was a passenger in the horse-drawn sled, sued the owner of the property in which the accident occurred, as well as the owner of the horses and of the sled, for injuries she suffered when she was thrown from the sled. The Wisconsin Court of Appeals found that the Equine Immunity Statute provided protection for the owner of the horse against tort liability. The plain language of the statute provides the immunity from civil liabilities available to all persons, including an equine activity sponsor or equine professional. Thus, protection is not limited only to those who are sponsors or professionals, rather the examples of types of people to whom the statute applies. Now, we talked earlier about persuasive law. Especially if this is a Wisconsin case, and this would be in minor contradiction to some of the cases we looked at, like the Tennessee case. Remember that any persuasive law can only come in just for the persuasive ability. No court in another state is bound by it. But I think you would need to look at your specifics of your case and your situation prior to utilizing it. But it is an interesting case and worthy of mention. The web has an incredible amount of information that will be beneficial to you in learning more about various Equine Activity Liability Acts and the Animal Control Acts, and just in general, animal law in general. Speaking of animal law, I have to go with my favorite, as the best website out there is www.animallaw.info. This is put together by the Michigan State University School of Law. It covers equines. It covers pretty much anything that deals with animals. It's an excellent resource, well-researched, updated frequently. I cannot speak highly enough about this crazy website. In fact, if you go to my site, ZippToCourtEquineLiability, you'll see a link to animallaw.info. Fantastic site. In Illinois, there's an Illinois-centric equine site with articles, info, and a message board at www.illinoishorse.com. I go there occasionally. I will say that in the message boards, I must caution you that there's a lot of misinformation that passes along on this message board and others throughout the state and the nation. It's best to go to animallaw.info, go to ZippToCourt.com, send me an email, look at the law for yourself. I've showed you on the very first slide how to look up the Illinois General Assembly laws. Make sure that your law that someone's discussing is on point and correct. There's a lot of misinformation out there. But I do endorse the www.illinoishorse.com as an excellent site for Illinois information on horses. Of course, there's my site, www.ZippToCourt.com, which we have a special Zip to Equines webpage that's built into that. That is built-in and designed for equine management specifically. I do offer some very, very reasonably priced horse packages that include sales contracts, rental contracts, leasing contracts, that type of thing, some advice on LLCs, and some other great information, as well as just in general court information and DUI information, that type of thing. I urge you to visit my site early and often. Another site that I thought was fascinating was the www.americanequestrian.com. Seems to be a very good equine association. They have some legislative updates throughout the nation, and they do offer some horse show and fair insurance information. I am not an insurance agent, and I am not an expert in that field, but it did seem to be interesting to me that there would be a company out there offering specific insurance. I would check with my insurance professional and see if this is worthwhile to you. And again, AmericanEquestrian.com seemed to be a good source for more information on point. Law review articles. These are professionally written articles, usually by law students or law professors. They're very specific to an on point. They're usually fairly lengthy, and you can find them. Those with law students and professionals who have access to LexisNexis, you can find them online through your initial subscription. If you do not have LexisNexis, you can get you can download these articles. I think they're about $12.50 a piece. They're very well researched, and might be worth your time. Might be worth adding to your library if it's something that interests you. A couple of their links are right here to those articles. Walking through the New Jersey Equine Activity Liability Statute, a look at judicial statutory interpretation in jurisdictions with similar limited liability laws. Excellent article. Does a lot of comparison. Pretty much, as I said earlier in the elsewhere in this presentation, almost every state has some form of an Equine Activity Liability Act or a rider on their animal control acts that limit the liability of equine activities. Another one was a survey of Illinois law, animal control law liability for animal-inflicted injury. It's a little more on point with for Illinois, and of course, if you're dealing with the responsibilities of equine and owner of an animal and the what can happen based on the liability of the animal owner. Both are interesting, though. Another law review article that you might find of interest is the Equine Immunity and Sport Responsibility Statutes, altering obligations and placing them on participants. Again, there's a link. I believe it's still $12.50 from LexisNexis if you don't have an existing subscription. This article might be something that might be of use to your library to add if you are a hunt club, a polo club, a horse show, and they're dealing. This walks you through how the last 20 years have evolved from placing all the liability on the organizer and the managers of shows onto the actual participants in equine activities. It's an interesting read, worthwhile to keep in your library if that's something that interests you, and something to look into. And finally, risk management. Regular inspection of your equipment, evaluation of participants' riding ability and experience, regular inspection of property conditions, promote safety awareness, post your operational rules, regardless of whether it's a barn, it's a club, it's an organization, anything, just if you have them, post them somewhere. Post equine activity liability warning signs, make sure you do that in a variety of places and do them strategically. Obtain release and or waivers. There's really not a big difference between a release and a waiver. A release releases you as the provider of the horse from liability, and waiving is they're acknowledging they're waiving the right to sue you. Just so you know, no one ever actually waives the right to sue. This is just something that you could utilize to help you with a defense later on. Obtain your appropriate insurance coverage. Again, I am not an insurance professional. I'm sure there is insurance that will cover the perfect for you. You should definitely seek out their expertise. Keep a readily available log of safety, inspections, repair receipts, and all efforts to mitigate your risk. This is just good common sense. It's good best business practices, and it will lead you down the path to probably a much safer and hopefully less litigious world. Again, I'm David Zipp. I'm a licensed Illinois attorney. I think that if you listen to this presentation, you've heard a lot Illinois many times. I can tell you that from my research and my experience, it doesn't look like there's an exceedingly different level of standards that vary from state to state, although the law does. I would urge you to look at specific law in your state if you're not in Illinois. Come to ZippToCourt.com, and hopefully we'll be able to help you with this. But again, thank you for your time, and be safe out there.